Okay, your court date is coming. The DA's office calls. They've got a deal. And every instinct you have says take it and make this nightmare go away. Stop. Before you sign anything, before you say yes to anything, watch this. Because DUI plea deal that looks like a lifeline can quietly wreck your license, your job, and put you in a terrible spot if you ever face another charge. I'm Sean Quinlan. I'm a Pennsylvania DUI attorney. Let's talk about what these deals actually are and when they're worth taking. A plea deal is simple in concept. You agree to plead guilty to a charge, and in return you get something. A lighter sentence, fewer counts, or a better outcome than gambling on trial. But here's what nobody tells you. A plea deal is not automatically a bargain. Sometimes it's just a fast way to lock in damage. The deal has to actually improve your position. If you're getting roughly what the law would hand you anyway, the only thing you got is speed, and speed is not the same thing as protection. ARD versus a plea deal. This is where I see people get confused. ARD and a plea deal are not the same thing. ARD, here having the meaning of Accelerated Rehabilitative Disposition, is a pretrial diversion program. It is not a guilty plea. For eligible first-time offenders in Pennsylvania, ARD can mean no conviction on your record. Complete the program, and you may be able to get your record expunged. A standard guilty plea, that's usually a conviction. That follows you. Now, ARD isn't a free pass. There can still be license consequences depending on your tier. There are fees, supervision, and conditions. But for most first-time offenders, there's a massive difference between ARD and just pleading guilty. If someone is pushing you toward a straight plea and you're a first-time offender, the first question out of your mouth should be, why am I not an ARD? What actually shapes your leverage? Think of a DUI case like buying a used car after looking under the hood. The value only becomes clear once you examine the details. The prosecutor's leverage depends on a few things: your BAC level, your prior record, the quality of the evidence. Your BAC level, Pennsylvania law breaks DUI cases into 3 tiers: general impairment, high rate, and highest rate. Each tier carries different mandatory minimums. Mandatory minimums are floor, not the ceiling. If your BAC puts you in a high tier, the room to negotiate shrinks. That's just math. Your prior record. A first DUI and a second DUI live in completely different universes. Second offense, jail exposure goes up. License suspensions get longer. Flexibility in sentencing decreases. A deal that sounded reasonable for a first offense could be a terrible result for someone with a history. The quality of the evidence. Was the stop legal? Were field sobriety tests done right? Is there dash cam footage? Were there problems with how blood was drawn or tracked? Weak evidence is leverage. Strong, clean evidence narrows the conversation. What's really at risk? Prosecutors like to frame deals around fines and court costs. Those are easy to quote, but the fine is often the smallest part of your problem. Here's what a conviction can actually do. Suspend your driver's license. Trigger ignition interlock requirements for months. Spike your insurance, sometimes for years. Show up on background checks. If you have a CDL, one DUI can threaten your commercial driving privileges. That's your livelihood. If you're a nurse, teacher, healthcare worker, or any licensed professional, you may have mandatory reporting duties to your licensing board. Just plead and move on is dangerous advice if your career depends on your record. How to evaluate whether a deal is worth taking. Here's what I tell clients. The deal should clearly improve your position compared to the realistic risk of fighting and losing. If it doesn't do that, it's not a deal. It's just paperwork. Before you agree to anything, get the exact terms, not the summary version, the actual version, and ask, what charge am I pleading to? And is it a conviction? What sentence is attached? Jail, probation, treatment, interlock, fines? Will I lose my license, and for how long? Is ARD available to me? What does this do to my CDL or professional license? How does this look on a background check? Get it in writing. Memory gets fuzzy fast when stress is high. Common mistakes. Mistake number 1. Rushing to plead just to end the stress. I understand the impulse. Court anxiety is real, but relief today can be expensive for the next 3 to 5 years. Mistake number 2, assuming every first offense automatically gets ARD. It doesn't. Prior history, whether there was an accident, the facts of the stop, all of it matters. It's my first DUI is one piece of the picture, not a strategy. Mistake number 3, forgetting the long game. One DUI conviction can affect your sentence exposure if you're ever charged again. Pennsylvania law uses prior offenses to set penalty ranges. What you agreed to today has a shelf life. Look, sometimes a plea deal is the right call. Sometimes ARD is better. Sometimes the case deserves to be challenged. But you can't make that decision in a hallway, papers in hand, when everyone around you wants a quick answer. Slow down. Get the terms in writing. Compare your options. If you've been charged with a DUI in Pennsylvania and you want to understand where you actually stand, reach out. The consultation is free, and it might be the most important phone call you make. Links in the description. Subscribe if you want more straight talk on Pennsylvania DUI law. I'll see you in the next video.